The federal government just tried to charge one man twice for pulling out the same gun one time. And all 9 Supreme Court justices, every single one, said no, you cannot do that, ever, in any state. Quick question before we continue. Are you subscribed yet? Because what I'm about to break down just quietly became the law of the land in all 50 states, and it directly affects every gun owner, every defendant, and honestly, every American who could ever face a federal firearm charge. This is not theory. This is not a maybe. This is a 9-0 ruling that already applies to you right now. Hit that subscribe button so you never miss updates like this one. I'll wait. Okay, let's get into it. Here is what just happened. On January 14th, 2026, the United States Supreme Court handed down a unanimous ruling in a case called Barrett versus United States. I want to say that again. Unanimous. That means every single justice, no matter who appointed them, agreed. Conservative, liberal, it did not matter. All 9 said the same thing. And what they said is going to change how federal gun charges work for a very long time. So let me start at the beginning, because the story behind this case actually matters. Back in 2011 and 2012, a man named Dwayne Barrett and a group of other people carried out a string of armed robberies in New York. They used guns, they used knives, they made threats. One of those crimes ended with someone being killed. Barrett was eventually caught, indicted, and convicted on multiple charges. His original sentence? 90 years in federal prison. Now, here's where this case gets really important for all of us to understand. The federal government charged Barrett under 2 different sections of the same federal gun law. Both sections deal with using a firearm during a violent crime. The first section is called Section 924 sub C. The second section is called Section 924 sub J. Think of them like this. Section C is the base charge for using a gun during a violent crime. Section J is the upgraded charge that kicks in when someone dies because of that gun use. The government said, we can charge you under both of these for the exact same act, with the exact same gun, at the exact same moment. That means Barrett was looking at 2 separate federal convictions for 1 trigger pull, 2 sets of penalties stacked on top of each other. Barrett's legal team fired back and said, that is double jeopardy. The Fifth Amendment to the Constitution says the government cannot punish you twice for the same offense. You cannot be convicted of 2 crimes if both crimes are based on the identical act. And the Supreme Court agreed. Here's the part that nobody is really talking about in plain language. The court did not just say Barrett got a raw deal. They set a rule that now governs every single federal court in every single state in the country. The rule says this: if one federal gun charge is entirely contained inside another federal gun charge, the government cannot convict you of both for the same act. Period. Now let me break this down for you, because the legal term involved here is worth understanding. It is called the Blockburger test. That name comes from a 1932 Supreme Court case called Blockburger versus United States. And here's all you need to know about it. The Blockburger test basically says if proving one crime requires all the same facts as proving a second crime, plus maybe one extra fact, then those 2 crimes are considered the same offense for double jeopardy purposes. The government can only get 1 conviction out of them, not 2. In Barrett's case, Section C requires the government to prove you used a gun during a violent crime. Section J requires the government to prove you used a gun during a violent crime and that someone died. Section J includes everything Section C includes. It is bigger, but it contains everything inside Section C. So under the Blockburger test, the court said, you cannot convict someone of both. You have to pick one. If you're finding this helpful so far, I want to make you a promise. My next video is going to cover the 5 words you should never ever say to a police officer when they ask about your firearm. Those 5 words have sent people to prison who thought they were doing the right thing. Subscribe right now so you get that video the moment it drops. It might be the most important 7 minutes you ever watch. Now, this is where it gets really interesting. Some people hear this ruling and think, wait, is the Supreme Court letting criminals off the hook? And I get why. It might seem that way at first. But here's the truth. That is not what this ruling is about at all. What the court is protecting is something far bigger. It is protecting the principle that the government cannot pile on charges just because it has the power to do so. Prosecutors across the country have long used what lawyers call charge stacking. That is when they list as many overlapping charges as possible against one person for one incident, because each additional charge adds more leverage during plea deals and adds more years in prison if convicted. Here is a hypothetical example to explain this. Imagine you are a gun owner. You get into a heated confrontation in a parking lot. Things go wrong. Someone gets hurt. The federal government decides to charge you. Under the old way of thinking, they could hit you with charge A for using a gun during a violent crime, and also charge B because the outcome was even more serious. 2 charges, 2 convictions, two punishments for one act with one gun. The Supreme Court just said that is unconstitutional when those two charges are made of the same legal building blocks. One act equals one conviction for overlapping gun offenses. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Every case is different, and the details of your case could change how this ruling applies to you. What I am giving you here is the foundation, so you understand what just happened and why it matters. Let me talk about Justice Gorsuch for a second, because his opinion in this case is fascinating. While all 9 justices agreed on the outcome, Justice Gorsuch wrote a separate opinion, what is called a concurring opinion, where he went even further. He said that the confusion in courts about double jeopardy and charge stacking needs to be cleaned up completely. He pointed out that Barrett was charged twice for the same offense. He was convicted twice. Before the Supreme Court stepped in, he was about to be punished twice, and Gorsuch said that is textbook double jeopardy, full stop. What Gorsuch is signaling is that this might not be the last word from the Supreme Court on this issue. He is essentially sending a message that future cases on charge stacking are coming, and the court may need to draw even stronger lines. So this 9-0 ruling is a beginning, not an ending. It is the first domino. Here is what most people get wrong about this decision. They think it only applies to violent criminals. They think it only helps people who actually did something terrible, but that is completely backwards. The constitutional principle being protected here applies to everybody. It applies to first-time defendants. It applies to people who make one bad decision in one split second. It applies to gun owners who genuinely made a mistake. The Fifth Amendment does not say the government can punish you twice, only if you seem like a good person. It says the government cannot punish you twice. That protection belongs to all of us. Hey, real quick, did you know that 73% of people watching this video right now are not subscribed to this channel? That means nearly 3 out of 4 of you are going to miss the next video where I break down exactly which federal gun charges prosecutors still love to stack, and what your rights are when they try it. Do not be in that group. Join the tens of thousands of people who already get these legal updates first. Click subscribe right now. It takes 2 seconds, and it could genuinely protect you someday. Let me now talk about why this ruling applying in all 50 states is such a big deal. The charges at issue, Section 924C and J, are federal charges. They do not come from any one state's law. They come from the United States Federal Code. That means when the Supreme Court interprets them, that interpretation applies everywhere. Texas, California, New York, Wyoming, Florida. It does not matter where you live. Federal courts in every single state must now follow this ruling. That is what makes this different from a lot of other gun law changes you hear about. State gun laws are patchwork. What is legal in one state can be illegal in another. But federal law is federal law, and the Supreme Court is the final word on federal law. When all 9 justices agree on something, there is no appeal. There is no workaround. It is done. Now here's the part that shocked me when I first dug into this case. The Trump administration actually agreed with Barrett on this one. Think about that. A man convicted of armed robbery and murder, serving time in federal prison, and the current administration's own legal team told the Supreme Court, yes, he is right. You should not be able to punish him twice for the same gun act. That is how strong this constitutional principle is. When both sides of the political aisle agree, when 9 justices agree, that tells you something important. The protection against double jeopardy is not a political issue. It is a fundamental American right. So what does this mean going forward? First thing, federal prosecutors now have to make a choice when the facts of a case could support both Section 924C and Section 924J. They cannot have it both ways anymore. They have to commit to one charge. Second, defense attorneys across the country can now use this ruling to challenge cases where prosecutors tried to stack these 2 charges. Some people currently in prison may be able to seek resentencing based on this decision. Third, and this one is huge, it reinforces that the Blockberger test is alive, strong, and being actively enforced by the highest court in the land. That matters for future cases far beyond just these 2 gun statutes. This is the information that changes how you think about your rights. And it is the kind of update that most people will never hear about because it did not make the primetime news. But you heard it here. Laws move fast. New rulings drop without warning. Subscribe to this channel right now because the next video covers which gun charges prosecutors still use to stack extra years onto sentences, and exactly how to protect yourself if you are ever facing a federal firearms investigation. That video could be up as soon as this week. Do not miss it. Let me close with the 3 things you absolutely need to remember from this video. Number 1, the Supreme Court ruled 9-0 in Barrett versus United States that the government cannot convict you of 2 overlapping federal gun charges for the exact same act. Number 2, this ruling applies in all 50 states because it is based on federal law and the United States Constitution. Number 3, the Fifth Amendment's protection against double jeopardy is your right and the highest court, and the country just made it stronger. The bottom line is this: you now know something that most people do not. The government has limits on how far it can push gun charges, and the Supreme Court just drew a new line in the sand. Knowledge is protection. If this video helped you understand something important today, please subscribe, leave a comment below about what gun law topics you want covered next, and share this with a friend who owns a firearm. Your next video is already sitting in my library. Just click that subscribe button so you can find it when it matters most. And finally, a quick legal reminder: nothing in this video is legal advice. This is educational information only. If you are facing any kind of firearm charge or legal situation, please consult a licensed attorney in your state immediately. They are the only ones who can advise you based on the specific facts of your case. Stay informed, stay safe, and I will see you in the next one.